Matthew, good to see you, sir. So take us to that moment where the judge is just furious at the prosecution. Why was that such a central moment in this case, and what does it mean for the result?
Because, honestly, this prosecutor seems to intentionally want to step over the line. It's almost like he wants a mistrial. And so everything that's led up to this point, right, all the voir dire, the going through all the pretrial motions, all of that, it's going to be good for nothing because there's a motion for mistrial now, and there's some pretty substantial items here at the table where this judge, if he does not allow for a mistrial, may be overturned on appeal.
So for those who are watching now but may not be, following this case on TV every single day, that line that you mentioned that the prosecution, it seems to be intentionally trying to cross, what is that line?
Okay, so this prosecutor has done two things that are substantially foul. Okay, number one is he's going into propensity evidence. Okay, first-year law students know you can't talk about propensity evidence. You can't talk about character evidence. This is to say that he acted in one way at one point, and today, the date of the incident, he's acted in that same conformity. That is character evidence. You can't do that as a prosecutor unless the defense opens the door, unless the defense starts to introduce good character evidence. Then the prosecutor can introduce bad character evidence. The second, and what I think is even more foul, is the fact that he's commenting on the fact that after Kyle was arrested, after Mr. Rittenhouse was arrested, he remained silent, okay? This is constitutional law. Even the judge called him out on it, said, hey, this is 40, 50 years worth of case law, worth of laws that we know. You can't comment on that. So it almost feels like he's intentionally crossing this line. He's asking for a mistrial.
Why would he want a mistrial? Is that your takeaway from this? Is an experienced attorney. This is not his first case, not his first trial.
I absolutely agree. I mean, you're in a high-profile case, Mr. Prosecutor. You really got to get this part right. But in actuality, I think that he's too close to the facts. And, what's crazy to me is that there's so much good material that he could use to cross-examine him, and he's not. He's intentionally crossing this boundary. If I was the defense attorney, I wouldn't have moved for a mistrial. I would have won this case. Then he would have backed him into double jeopardy. He wouldn't have been able to bring any other claims against my client.
Central here, though, are the self-defense argument that the defense is making. What about those claims? Are they holding up thus far through this trial?
Well, I think so. The prosecutor in opening statements said that, Mr. Rittenhouse shot someone in the back, okay? When we look at the footage, it's squarely true that he shot him in the front, okay? This is central to self-defense, and you've lied to this jury. How can they trust you now? So ultimately, there are some really good pieces of evidence here that show that this was actually self-defense. He was being attacked, right? There was even an expert, a medical expert that came on and talked about burns to the hands of the victim. And really, that's to go to show that he was trying to grab the gun. He was trying to wrestle the gun away. And that's when the shot fired off. It's square in the self-defense theory.
So do you feel we're headed towards an acquittal?
I think we're headed towards a mistrial, unfortunately, and what that really means for this defendant is he may be tried again. If there is a mistrial here, there are two ways that this judge could come down with it. It could be with prejudice or without prejudice. 99% of the time, it's going to be without prejudice, meaning that the prosecution could now bring claims one more time, and it wouldn't abridge the double jeopardy laws.
Attorney Matthew Barhoma, really appreciate your analysis this morning. Thank you.